30,000 parents who are registered prospective adoptive parents waiting for adoption. And the children, my lords, here who are in the pool are less than 1,500. There is a mechanism for, my lords, you have to reserve every prospect, and then, my lords, there is a mechanism for intra-country is the last resort.
Only 1,500 children are available for adoption across India?
My lords, yes. And not yet available. They are in the pool. My lords, because there is a time period that's available for children who are surrendered. The biological mothers or parents can reconsider if they want to. So there is a mechanism that is laid down, my lords. And then they are put in the, my lords, I've given a flow chart also of how adoption happens. It is only through Carings portal. No interference by humans. It is a portal that is automated, my lords, completely. The option goes to the next in seniority as a prospective adoptive parents. They are given 48 hours. They have to give their ethnic background, their choice, gender choice. My lords, the home study form that's a schedule in this, my lords, in these regulations is so exhaustive. You have to disclose not just your health conditions, income, your parents, your other family members, your children. My lords, it is so comprehensive that because it's important. Where the child is, because there is a process of matching that has to happen. After the parent decides that this child might be fit, there is a matching that has to happen, and it's only after that matching that the child is, my lords, given.
Just a question, out of curiosity. We appreciate how much effort has gone into ensuring that the child is safeguarded in every which way when he or she goes to a home. What is the timeline ordinarily for an application once a party applies, a parent to be applies, and it matures by actually handing over the child to that adoptive parent?
I've given that in my that.
Do we have data?
But 3 years.
Do we have data of neglected children who are in care institutions and who are not, of course, not adopted, and who after turning 18 go? I mean, I won't use the word they are turned off, because care institutions don't cater to any adult.
Yes,
At the age of 18, if the child is not adopted or not cared for, in the sense that there is nobody to sponsor her or him, and he becomes an adult.
Yes, ma'am.
What is that? What is the future of that young adult who was a child till then? We have, I mean, there is no data. Actually, there is no data. And if you say 30,000 applicants are
prospective parents,
of prospective parents, then 1,500 only are available.
Yes.
Isn't it a matter for concern that we look into every care institution? And there are thousands. We have, at least in Delhi itself, more than 50.
My lords,
in Tamil Nadu, we have, I think, 250 or so.
My lords, this is the data of, well, if your lordships will see page 2 of my yesterday's compilation of legally free children available as on 28th of April 2023. The CARA guidelines prescribe a procedure in which the child has to be declared free for adoption. My lords, it's a very razor thin edge walk, my lords. The child is being separated from biological parents, surrendered parents, or orphan, my lords. Orphan also, my lords, there is a provision for family adoption, because, my lords, our culture, we are polycentric even in families. There will be nani, dadi, masi, mama, buas, whole lot, my lords, and they have right of, my lords, accelerated rights of adoption for family members. So there is the whole process. If the process is not followed for declaring the child legally free first, before giving up in adoption, it is going to. I just want to quickly, my lords, just tell your lordships what the rest of my note is. Lordships will just see that, my lords, I have also, my lords, I've adverted to in between the ART and the surrogacy mechanism is also like that. I just quickly want to mention this, my lords, the National Board of Surrogacy and ART, they were referred some, my lords, issues that why are you not allowing donor gametes in a surrogacy? My lords, the answer very clearly that has come from them is emotional bond of the child is very important. We can't even take 1% chance. So they say between the egg, the sperm, and the uterus, at least 2 of them have to be of biological parents. So while ART allows donors, surrogacy, where you're using the uterus or womb of another woman, altruistic, no commercial, because now the regulation is very clear. You can't use donors. though my lords, Court 5 will deal with those challenges, but the reasoning that has come is that there has to be a strong emotional bond of the parents who are going for these assisted mechanisms. My lords, we have given, I think I've covered most of it, my lords. I would draw your lordship's attention to, my lords, one more aspect. The special provisions with regard to children, to women, my lords, is also something that your lordships will have to look at very carefully. We have made a compilation of, my lords, laws where women are protected by virtue of their married or domestic relationships.
Thank you, Ms. Bhatti.
And my lords, one more thing, we made a chart of these 34 countries which have in some manner recognized their civil unions, though it's a phenomena only of this millennium, my lords, but they have recognized. We made a chart, my lords, we've given a source of that also. 27 of them have gender neutral rape laws. Social fabric is different, my lords. That chart your lordships will find, my lords, in our compilation C at page 1492. The source is also there, my lords. 27 countries gender neutral, 4 are gendered, 3 we could not confirm because they were in languages, my lords, though we tried AI of the internet to get the sources. My lords, I'm very grateful to your lordships. I had, my lords, just written an opening line. If your lordships will permit, I'll read it, my lords, at my closing. The entire endeavor of ours is to present to your lordships that the architecture of child-centric or child welfare laws is very carefully crafted with welfare of child being paramount. Any general declaration reading in spouse instead of husband and wife will make laws relating to adoption, assisted reproduction, surrogate reproduction completely unworkable. Even for the legislature, my lords, which has the tools of wide consultation, expert and specialist advice, my lords, options of calibrated and gradual solutions, opportunities of amendment, savings and repeal. That, to my mind, is a very, very important tool, my lords. The option of adoption, savings and repeal. My lords, they will also find it very onerous responsibility to balance, on one hand, the competing rights, and on the one hand, protecting the parents' patria responsibility of the welfare of the child, because that is non-negotiable.
All right. Thank you, Ms. Bhatti. Thank you.
I am very grateful, my lords. Your lordships have given me this opportunity.
Yes, Mr. Maninder Singh.
My lord, only a couple of minutes, my lord, because the written submissions are already filed. My lord, if your lordships kindly have, my lord, the written submissions coupled with the small compilation of judgments, my lord, which are in our name. Because I tried to find out the PDF number, I was instructed, my lord,
No,
to...
We have the written submission.
Yes, my lord. Now, I have only 2 points to make, my lord, in support of the same submission.
What are the 2 points?
Yes, my lord, first of all, on the point, my lord, that under Section 4 of the Special Marriages Act, by virtue of, by process of interpretation, my lord, it may not be permissible for recognition of same-sex marriages.
Just 1 second. Yes.
Well, under Section 4 of the Special Marriages Act, all sub-clauses are conditioned in addition. I don't want to repeat.
And what is the second point, Mr.
Second point is, my lord, on that as late as 2022, my lord, I have placed 3-4 judgments of your lord, my lord, of the different courts, which, my lord, 2 are Privy Council and 1 is from Hong Kong, my lord, where 2 out of the 3 judgments where similar rights had been claimed, my lord, were declined. And in one of the judgment, constitutional validity of declining this right, such a claim, which was placed before the court, my lord, is rejected. That is, that a provision we say, no, there would not be any recognition to same-sex marriages, which was put in question on constitutionality, is declined. My lord, if your lordship will just have a look at the judge, small note, my lord, I'll just...
Yes.
The provision.
It's like that DOMA, the DOMA.
Page 18.
Yes, my lord.
DOMA was struck down. Here you say DOMA was upheld.
Yes, my lord.
Page
yes,
18.
your lordship is right.
Page 18 of your submission.
Yes, my lord, if your lordship may just give me, only make a note, my lord, in para 14, we have also relied on section 112 of the Indian Evidence Act in support of the first submission. And then, my lord, if your lordships come to para 16, my lord, which is extremely important.
1/6.
Yes, 1/6 at page 7, where provisions of 3 personal laws, my lord, where there is that ability to procreate, which is one of the conditions in section 4, is a ground for divorce. In all the three, my lord, personal laws of Hindus, Christians, and Muslims, which is, my lord, mentioned in para 16. And then, my lord,
At the present,
if your lordships rightly, my lord, pointing out
Those foreign cases you wanted to show.
yes, my lord, page 19 bottom, the Italian Constitutional Court, my lord, where the Article 29 of that, my lord, Constitution, which, my lord, is reproduced at page 11 of the note because a reference is made earlier. Just make a note of, my lord, Article 29, which, my lord, was very wide, much wider than section 4 of our Act.
Article
where-
29, where, Mr.
My
Sorry,
lord, if your lordship may kindly see page 11,
21.
page 11 of the note,
Right.
Para 21.
Okay. Thank you.
page 11 of the note, my lord,
This is that Oliari, the
Yes, my
judgment
lord.
of Republic.
para 21, Article 29, if your lordship may kindly see the second part of it, marriage is based on the moral and legal equality of spouses. So, my lord, by repressing this word spouses when the right was claimed, my lord, that is declined at bottom, my lord, page 19 bottom, going up to the next page. Kindly see para 31. And, my lord, if your lordship permit me, I've kindly come to 20 and 21, extremely relevant, my lord, and your lordship may also keep two things in mind. The argument of discrimination and classification, which Mr. Dwivedi had also addressed, I don't want to add. And, my lord, the benefits to flow from such recognition, which, my lord, an argument raised here also, both the arguments raised, both are taken up squarely, my lord, directly, and, my lord, debated, considered, and declined.
You cited Oliari as well as.
And, my lord, yes, my lord, and your lordships have considered Oliari in, my lord, the page's judgment, but if your lordship may kindly
Para 34 is your Privy Council judgment.
yeah, and, my lord, Privy Council, in one of the judgment, my lord, just give me a moment.
Of Cayman
That is
Islands.
Page 21, last two paragraphs above 32, both the grounds of discrimination and other benefits which flow from such a legal recognition of marriage have been considered. And if your lordships kindly come to 22, this is para 34 is the, my lord, first judgment of 2022, my lord, by the Privy Council, where, my lord, section 14(1) of Bill of Rights was, my lord, which is reproduced in para 34, and then, my lord, the consideration thereof is up to page 24 of my note, and, my lord, which was rejected. Kindly come to para 36, which is that section 53, my lord, of Domestic Partnership Act, which created a prohibition against such a recognition. It's extremely important, my lord, for your lordship's kind consideration. The Domestic Partnership Act of 2018, where section 53 created a prohibition, the constitutional validity was challenged, and, my lord, after consideration, at para 76 and 77 of that judgment, which is reproduced at page 24 and 25, it is rejected, my lord. In Hong Kong, my lord, which is para 37, which is also, my lord, 2022, a similar, my lord, discussion has taken place. Similar contentions have been considered. And if your lordships kindly come to page 27, my lord, para 77. Kindly read, I'll just read para 77. Your lordship may kindly have regard to the other portion, and I have to place the judgment copy also in the second compilation. Kindly come to para 77. In terms of access to the institution of marriage, it concerns the special status of marriage, which is a distinct concept from the benefit arising from it. The difficulty or even perceived hardship involved in obtaining the benefits of means of legal challenges does not justify a shortcut bypassing BL 37, my lord, which is Basic Law 30.
All right, Mr. Mahendra Singh.
That's
Thank you.
with respect to
Thank you,
submission,
Mr.
my lord. And judgments are, my lord, enclosed. The full text of the judgment
Yes,
is placed
Mr.
for your lord. I am deeply obliged, my lord.
Thank you, Mr. Mahendra Singh.
Please, your lordships. My lord, I appear for the Akhil Bharat Sant Samiti. I'm not going to repeat anything, my lord. Most of the points are already covered. In fact, I'm adopting, my lord, all the points. I've already filed written submissions. Only 2 points, my lord, I wish to highlight. A, my lord, the concept of marriage in the Indian society is creation of an institution. For example, in the Hindu law, it's a sacrament. Muslim law, it's a contract.
The concept of marriage in Indian society is?
Is, Lord, an institution by itself. Whether in Hindu law it's a sacrament, so it is a divine angle. In the Mohammedan law, Lord, it's a contract. Now, various facets. Now, Lord, concept of same-sex marriage, therefore, would be virtually like an attack on the very institution of marriage which has been traditionally known in this country. And Lord, we have to be very clear about it. There is no doubt that in Nautaj recognizes the right to privacy. Lord, right to privacy is recognized, but your lordships have seen that, Lord, observation, where they have said, by this we don't mean the marriage, it's the union.
Right. What is
The second point, Lord, that I want to tell your lordships is, if your lordships have a look at the sections 19, 20, 21A of the Special Marriage Act, Lord, if you marry under this law, Special Marriage Act, then it's not connected to the Hindu Marriage Act, but it also provides that the two Hindus can marry. Now, if two male Hindus or not two female Hindus marry thereafter, what implications is going to have on the other law? That also is required to be seen. Creating, Lord, a mere civil union is fine. That therefore there would be no problem about a civil union or a declaration that they need not be harassed, or because it's the prohibition part, Lord, is a different aspect. But creating an institution of marriage itself, giving them all other rights, Lord, will interfere with all other.
Yes.
So you are saying that there is no problem with a civil declaration of a civil union per se, but
Civil union, Lord, and that already has been given in the right to privacy. By privacy, you may, Lord, in fact, in my written submissions, I have highlighted and I have said so. That declaration of civil union is a different thing. But insofar as creating them as an institution of marriage will be virtually. And number two, Lord, India as a country, one has to see, like Roscoe Pound said, law is a concept of social engineering. It has to keep time. But India has not, Lord, reached that level where, Lord, this institution of marriage can be permitted at this stage. Lord, the rest of it, your lordships would get in my written submissions. I'm not troubling because there are other lawyers also who have to argue.
thank you, Mr.
I'm obliged, grateful to you, Lord.
Mr. Sai Deepak will argue now, or Mr. Manisha will argue this.
Look, the state has filed an intervention application seeking to respond to various petitions praying inter alia for a judgment and judgment declaring the marriage between persons belonging to the LGBTQI community as legally valid in the context of the Special Marriage Act in the Hindu Marriage Act. Lord, my Lord's Ladyship, I've had the privilege of hearing the arguments of the Attorney General, the Learned Solicitor General, and other counsels preceding me. I'll abide by the two regulations circumscribed by the Honorable Court, one being the time constraint, the other being not reading out any judgments. My Lord, I've formulated a few points, my Lord, for consideration of the Honorable Court. But even those, my Lord, I shall not be going into in detail. Let me just briefly
Can you
relate.
formulate that, Ms. Lavkumar? So we can
I
just
have
formulate.
formulated them, my Lord. I'll just briefly read it. There's only one point on which I propose to take the Honorable Court, my Lord. My 4 points which I have formulated relate to reading up, reading down, updation of the existing law, governing marriage, especially the SMA, to include non-heteronormative unions would lead to altering of the cultural edifice. You know, substantially already dealt with by the other councils. I wouldn't delve any further into it. necessity for a wide consultative process and comprehensive deliberation by the legislation, also has been extensively dealt with by the learned Solicitor General. This is what I wish to further highlight, this and the next point. It is not a case of exclusion or prohibition, but a case of non-inclusion in a targeted legislation enacted with special aims and objects. And taking this further from the deliberations, as transpired in the court yesterday, tracing any right of recognition by whatever name called, within or outside the framework of matrimonial laws, would result in the creation of a new institution, dehorse the democratic process. The inevitable ripple effect on numerous legislations, and of course, submissions with regard to the Foreign Marriage Act would get covered in the submissions already made with regard to the SMA. If time permitting, I'll make a 2-minute submission on that. Marriage as a socially recognized institution and the foundation of the Indian family unit, I wish to submit that it is marriage between a man and a woman is at the core of the family. The Indian society is founded and organized around this concept of the family. The rules of marriage continue to evolve, but they remain grounded in organizing of heterosexual relationships. The interest of the state, considering the importance of this institution, the interest of the state in regulating of marriage lies in the overarching interest to preserve social order, ensure progression of society in a legitimate manner, and to regulate matrimonial conduct. In that sense, marriage as a legal institution is not a private affair between consenting adults. It is a public act between two consenting adults who are then conferred a legal status by the state upon fulfillment of statutory requirements. I then would point out that the SMA is part of a wider spectrum of all enactments relating to what we may be broadly calling matrimonial laws, whether in the realm of personal laws, whether SMA, whether FMA, all are heteronormative in structure. I have excerpted by way of a table that all these laws carry certain features which would be considered as the core fundamentals or the thrust of the legislation. Namely, all of them refer to as heterosexual unions, all of them prescribe monogamy, all of them prescribe minimum age of marrying, and all of them carry prescriptions of prohibited degrees. They may vary from legislation to legislation, but all of them are uniform in that sense. The fundamental of marriage, before my lords, is a matter which has very serious consequences in terms of its depth and breadth, considering that my lords are examining not just the validity of an act, namely the SMA or the FMA. My lords are examining the very edifice of family institution, social structure, myriad of matrimonial enactments, and based on those myriad of matrimonial enactments, my lords have succession enactments, divorce provisions, maintenance provisions, adoption and maintenance. So it's an entire regime which is regulated. And all of it which is based on heteronormative. So it is an entire regime. Looking at the act in isolation, would not be possible, considering that it is all on the same platform. All heteronomous, all with these embargoes, all having regulatory nature, and all on the same platform. And built on this is entirely a regime of other enactments, and more importantly, social legislation, benevolent legislation, namely for Evidence Act, 113A, presumption, or Dowry Death, presumption, 113B, or Dowry Death Act itself, or Stridhan under the Hindu Marriage Act, Section 8. So there is an entire edifice which is created around the institution of marriage.
You may read para 6 if you don't mind.
Please, my lords.
Page 11 of your note.
The rules of marriage continue to evolve, but they remain grounded.
Sorry, this is para 6 of page 11, social
Page.
institutions.
Brief note?
To the written submission.
Para 6. My comparison.
After the chart,
Yes. Give me my.
the chart which you have given,
Yes.
so 2 pages later, this is part of note subpara 3.
Yes.
Yes, please read that.
The institution of marriage.
Yes,
The institution.
social
It's
institutions,
PDF 13.
PDF 13, yes.
PDF 13.
11. Printed 11.
13, Baba. Come karo.
This is
46
Mera-
pages paper book.
Give me my compilation from there.
social institute.
Please. Social institutions consist largely of interlocking set of ideas that regulate or affect the way people actually understand and behave across interpersonal relationships. The meaning of social institution matters, and the institutions that bear it serve to structure our experiences and steer them in a particular direction. They define our goals, focus our attention on those goals, and direct us towards them. Changing the public meaning of a social institution leads to changing the institution itself. The concept of same-sex marriage is not within the percept of Indian personal law and legislation. Obliged. So, my lord, I have pointed out that the rules of marriage may continue to evolve, and they need must, but they continue to remain grounded in organizing heterosexual relationships. We have additional grounds for divorce being conferred. Over a period of time, my lord, even 21A is enacted in the provisions of the SMA to ensure that now Hindu laws relating to succession, etc., would be made applicable. And they must evolve. But the normative structure still remains heterosexual. My lord, taking further from that, my lord, over and above the interest of the state in regulating, my lord, I wish to point out to the Honorable Court the argument at which, my lord, the deliberation rested yesterday was with regard to tracing any right with regard to cohabitation into Article 21 as expounded, my lord, in Navtej. So, my lord, Navtej has already granted them the right to cohabit, physically, emotionally, sexually, unfettered. My lord, my submission is that contemplating tracing of any right, of any legal recognition of the right to cohabit would amount to creating a new institution outside, my lord, the legal framework. My lord, an endeavor was made, my lord, to read the SMA in a gender-neutral manner. And the Honorable Court went through elaborately provisions as contained in Section 4C, provisions as contained in 4D. 4C was with regard to age, reading in a gender-neutral manner, age. For male, it was 21 years, female, it was 18 years. As sought to be made applicable to gays, possibly yes, to lesbians, yes, but they are not representative of the entire community. My lord, LGBTQIA. So there are.
Could you just, you've used a very interesting expression, juxtaposing the argument of the petitioners to the bouquet of rights.
Yes.
You call this as the sanctification.
That's right.
The sanctification narrative. Could you just explain this in 2 minutes? What do you mean by the sanctification narrative in the context of heterosexual relationships, heterosexual marriages?
My lord, my submission is that this principle of sanctification lies in the fact that the institution of marriage predated any legislation. Legislation recognize this social, cultural, pluralistic acceptance of this heterosexual union across societies, communities, and regulated it in a manner that was most beneficial to public order, sustainability, procreation, ensuring the best upbringing of children. And the regulation does not end at marriage. The enactment provides not only entry points, also exit points, the manner in which you exit, an organized manner, grounds for divorce, maintenance, Who gets responsibility for it? So this is an entire genre, a regime created. Now recognition, the petitioners endeavored to look into this SMA as well as the FMA and read it in gender neutral manner. Milord, hypothetically, just taking the example of prohibited relationships under section 4D. My act, please. Milord, under 4D,
Thank you, Mr.
yes. No, my lord, would my lords, I need to make one important submission. If my lords be pleased to turn to my note, which I forwarded yesterday. I wish to hurriedly go through that. I'll take 5 more minutes. My lord, it's a 5-page note mailed yesterday.
Yes.
My lord, part 3, consequences of any declaration.
Sorry, Ms. Lavkumar, there's a 9-page.
9-page note. I stand correct. It's a 9-page note. I'm only going on part 3. That's all I wish to, my lord, read.
Part 3.
My lord, it would be page number 3. Page number 3, part 3.
Yes.
My lord, any declaration of from this honorable court would have very serious ramifications. The edifice of matrimonial laws and ancillary laws are extremely regulated. Sans any regulatory regime, a judicial recognition would create serious social and legal issues. My lords, please to note, Section 4 had a bunch of regulations, age prescription, prohibition related, prohibited relationships, bigamy, etc. Any recognition would become a law within the meaning of Article 141, and it would be binding on, my lord, the entire judiciary, and plethora of litigation would come seeking recognition. But dehorse this regulatory regime. Tomorrow, my lord, Navtej only talks of consenting adults. What about prohibited relationships? What about bigamy? My lord, there is no regulatory regime. Any recognition dehorse this regulatory regime would have serious consequences. I also point out, my lord, that entry 5, list 3 of Schedule 5, Schedule 7 empowers the legislature to enact laws with regard to marriage, divorce, adoption, wills, etc. This court, my lord, ordinarily would not arrogate it to itself the lawmaking prerogative. My lord, it is further submitted that the petitioner's apprehension is completely misconceived that the parliament would not look into it.
Yes.
My lord, the apprehension of the petitioners in seeking recognition of either marriage, a relationship akin to marriage, or by any name called, is misconceived on the ground that the legislature would decline to examine the concerns of the entire community, seeking legal recognition within the members of such community. And it is only this honorable court which would declare. You know, my submission, this is a circuitous route. Ordinarily, the honorable court would leave it to the parliament. It has various multifaceted dimensions, all to be deliberated, social consensus, a large number of debates, and conflicting views. Those adversarial views are important to evolve, my lord, a consensus on this issue. When to be done, how to be done. Rather than go to the parliament, the first endeavor was read into the SMA. When not fitting into the structure of the SMA, now seek a declaration apart from the SMA, which would have even more serious ramifications. And all arguments which are made applicable in the context of SMA would be equally applicable, my lord, in this context. My lord, would my lords now turn to para 20?
Thank you. I think we'll close it here, Ms.
Just one submission, my lord.
Yes.
By giving a declaration of the nature contemplated, my lord, this honorable court would unintentionally be foreclosing debates in society,
That we have.
foreclose the rights of society to
We have-
determine. And my lord, finally, my lord, such a declaration would hamper the genuine, organic, and sustainable change in society, which is reflective of the democratic ethos of the working of the Constitution.
Thank you, Ms. Milner.
My lord, I conclude by saying that, my lord, it's not a simple class of mere declaration of a result. It has very, very serious ramifications in considering the entire marriage regime and the ancillary social laws which are involved.
Thank you, Ms.
Grateful to you.
Thank you. No, we'll first hear Mr. Sai Deepak. He's got an order which has been given to us. Yes, Mr. Sai Deepak. Can you just formulate what will be your line of
Lords, with my Lord's permission, given that I have only 20 minutes, and which I expect may not even happen, I'll do my best to simply formulate my position. And as opposed to reading out from anything, kindly allow me to just engage in the bench, because my written submissions capture my position that's already been shared. So there are two aspects.
Just give us 1 second. We'll just go to your written submission. So as we are arguing, we can also keep a track of your submission.
If I may, Lords, an additional written submission.
Additional submissions or the original one?
The original. The additional is a one-page note, and I'll anyway address it. So my Lords could perhaps refer to the first written submission.
So what is broadly the line of...
Lords, if I may say so. The first law of thermodynamics effectively encapsulates the entire position when it comes to physics, and from there all corollaries flow. So the central position that is effectively placed before my Lords is with respect to the distinction between fetters and powers, which is to say whether this particular area which the petitioners seek to espouse before my Lords is an area which falls within either prohibited areas, or is it something that falls within the area for my Lord's adjudication. That is the central issue. And I think that is the forest that is thought to be presented before my Lords. I am here to perhaps unpack a few leaves for my Lord's consideration. The question of legislative competence is just one aspect of the issue which hinges on separation of powers. But I go a step further, which is to say that when the petitions raise the question of change in heteronormative attitudes, does the society have a right of agency to participate in these proceedings or not, at least in this particular issue or not? Because this is not a question of separation of territories between different organs of the state, but it fundamentally hinges on the right or the agency of the society to participate in this particular discussion. And that is the central problem when these kind of issues and subjects are taken up by the court of law, as opposed to leaving it for legislative prerogative to apply its mind. Point number two, during the course of these proceedings of the last 2 weeks, quite a few times I've heard the submission being made that it's a liberal democracy, it's a liberal document, so on and so forth. Does it mean that social conservatism has absolutely no place within the meaning of the Constitution? Does it mean that the society does not have the right to draw a few red lines to basically say thus far and no further? That is the central question. I represent a women's organization which equally represents the right of children, and therefore, as a civil society organization, the question that is being raised is that the nature of the prayers raised in the petition has the consequence of individualizing a socio-centric institution such as marriage, which is to say, as long as it is a transaction that takes place between two individuals who are consenting and who are not prohibited by any prohibition of degrees, so to speak, the rest of the society has absolutely no say as far as this institution is concerned. This, I'm sorry to say, fundamentally demeans the institution of marriage and takes away its social character. So these are the meta questions that I think which arise for consideration before this honorable court when these kind of petitions are filed. I'm sorry to say this, and let me try and perhaps tone down the rigor of my submission to the extent of saying, I believe that they have a cause. I just don't believe they have a case. The cause is different from the case. And it is important for the court to seriously consider one aspect here. When there are issues of legislative competence, there's another figure, so to speak, which is involved. And that figure's powers come under Article 111 of the Constitution, which is to say that if a legislative proposal ultimately meets with the consent of both the houses, ultimately it has to go to the Honorable President. And the Honorable President also has the power to recommend amendments to a legislation. Therefore, this is not just a question of legislative prerogative or legislative sovereignty, either from an external or an internal perspective, but there are multiple dramatis personae and stakeholders of this particular equation, the society being the chief. Because ultimately, the petitions raise the question of changing the paradigm with respect to heteronormative attitudes of legislations in general. It is not just about the SMA. Plus, my lords is not dealing with the religion-specific legislation here, it is the SMA, which means all the more the society's participation when it comes to the SMA is warranted, is mandated, is compulsory. Because at least if it were to be with respect to certain, let's say, religion-specific legislations, it can be said that there is an identifiable group which has a locus to